was
Mr. Mitra, kindly answer one query. Interview was 5
interview five.
marks. Aptitude was 5 marks.
Five.
Board of interviewer was the same in respective districts.
Hmm.
And where interview and aptitude was held at the same date, same time.
Same time. Yes.
So uh, one view was that when interview there is 5 and aptitude there is 5, how are you assessing the candidates?
Hmm.
For interview, what is your name?
Hmm.
You belong to a family. What does your father do? Maybe these are individual questions can be asked. Now aptitude, the learned single judge, subject to what you say,
No, my lord. Right.
his lordship wanted to know that actually what questions are put in aptitude.
Yes.
But as there was an amalgamation of two traits in one particular sitting,
Hmm.
maybe the judge was of
Yes.
the view, maybe the judge was of the view that in the guise of holding a aptitude test, you are giving full marks for that test.
Yes. Some of them full marks. Yes.
This could have been
Yes,
one
yes, yes.
one angle.
Hmm.
Now, to that, when there is no segregation from interview and aptitude, suppose I appear in an examination, you put some questions in interview, you give me 2 marks out of 5. Now, for aptitude must be also, Mr. Mitro, you must be putting some specific questions to me
Yes.
to
Yes.
determine my aptness.
Yes.
How I will determine her? So, in certain examinations, we have seen, subject to be corrected, that the blackboards were there. The person was asked that you make out a figure. What you will teach to a primary student, what you will teach to him. So I think there was the confusion, which ultimately the court was of the opinion that there is no specification. 5 there is there, but you have amalgamated everything and you have given 9.5 to a person who in qualification in academic may have got only 4.
Yes.
And by that you have enhanced the marks. I think that would be, we have not yet heard them. So what would be your answer
Yes.
to that,
Yes.
Mr.
Oh, bless you. What is not that what questions they were you asked? If that would be relevant thing, but that was not the judge's question. Question was how many questions were asked. I fully appreciate and really grateful to my Lord, my Lord. It would have been very apt to ask these candidates what questions were asked of you regarding your aptitude. That would
These interviewers themselves were not competent. That is where the judge proceeded.
that this proceeding, the interview was not.
The interviewers, the persons who took the interview, they
Correct.
themselves did not
Correct.
know what is interview and what is aptitude.
Yes, that is my next part of evidence. Come to that, Lord.
Yes.
I will first dealing with the question interview. Now, my Lord wanted to know that what is aptitude test or etc. And what is
That the judge has called for a report from.
kindly Miller see Rule 2, Sub-Rule C of the Recruitment Rules, Volume 1, page 112. দিয়ে দাও, আমি দিয়ে দাও।
paper book amended rules are there. Amended. Amended. Both you see is same, but other portion.
আচ্ছা তো 2C,
You are showing us 112.
Rule 2C. What is aptitude test is defined in the rule.
Yes, it is defined.
So, that question, court should not have asked any witness. What is aptitude? Do you ask all the witness? What is aptitude? Do you know? That was not the question to be asked. Please will not come to definition. Rule 2C.
Yes.
Aptitude test means a test to assess natural teaching ability of a candidate. The court has to go by this. Why ask the questions to all the witnesses? Do you know what is aptitude test? And question it, how many questions? 2 or 3, sometimes 3 or 4, things like that. They will not. I agree that there are a lot of things to be said on the part of the board, on the part of the judge also, a lot of things. You have to weigh this. I am not saying that I have a foolproof case. I have not yet come across any foolproof case in my 64 years of career. A whole case has some weakness, some good point, bad points. It is as it is not a matter between Ramakrishna Paramahansa Dev versus Swami Vivekananda. So there will be some weak points and bad points. You have to weigh the balance. Only question, that more important question, your lordship, is did the judge made a correct approach? If am I wrong, sir? Similar, therefore, it's a wrong approach to ask any of the candidates. What do you know what is meant by aptitude test?
Yes.
Now, the selection process, the system of marking was not challenged in the Reach petition.
That was not challenged.
Although Miller's petition has been filed 5 years after selection been made.
That too without making you parties.
Yes. So Miller, let us go by selection process, right or wrong. It fundamentally, absolutely fundamentally wrong. There are 50 marks in total. 50 marks in total. Out of that,
Yes.
50 in total, out of breakup is 40 marks are to be given arithmetically by arithmetical calculation. What marks you obtain in that examination, written examination, BA or thing. Breakup to 0.
No, that is there in the
So 15 that. Though that was 40 marks will be given by arithmetical calculation. No question of any scope of arbitrariness or personal whims. 10 marks only out of 50 left for interview and personality test, aptitude test. And question to be asked to find out what is the teaching ability. Yes. Now, please, minute, now see the one thing from the we will go by the record simply.
Yes, Mr.
I will go by. There is no recording that cross-examination declined.
Yes, that is.
You go by the records.
There is an observation that no one sought for cross-examination in the judgment.
That's in the judgment.
In the judgment, the judge said.
Judgment. But I am saying that normally.
Yes, all right. No cross-examination.
Decline, etc. They are not recorded.
No, it was recorded that.
There is nothing to see from the records that
no question was asked by the appearing parties to the above interviewers.
Yes.
6th of February order.
6th. No question. The court has recorded that. Now, my lord. So, now come to a very grave case, my lord. Important case. Important aspect. ভোট কি বলেছে তোমরা ডিক্লাইন করেছো কি ভোট কেন আনছো তোমার
George's predisposition to
Yes.
Order record that some on order, the board did not pray for cross-examination. Board is to answer, not for me. Anyway. But one fact remains as a very grave fact. The persons who will be affected by the evidence very directly, namely persons who had been successful and got their job for the last 5 years, they were not given any opportunity to cross-examine.
Hmm.
They had no opportunity to cross-examine, no notice was given to them. So now the question arises for before Lordship, which I humbly placed for my Lord's kind consideration. What's the value of a cross-examination? Sorry, value of an examination chief done by the judge of anybody, which is not subject to cross-examination by persons affected.
Hmm. Hmm.
Isn't it? Cross-examination in humble submission is part of natural justice. It's not statutory law. Cross-examination.
Yes.
That if the cross-examination and order was confined to against board officials, I wouldn't mind. But on the basis of this finding, court has upset. Now, with our humble submission, there are humble judgments of different courts. That what is cross-examination? Is a part of natural justice. And evidence without cross-examination by the parties to be affected cannot be relied upon by court. So my submission would be not only these interviewers, these petitioners who were cross-examined, could not be relied upon by the court for annulling the employment of the non-parties.
Yes, we got you. Got you.
Got you one. Milord, judgment দাও। দেখো কোনটা লিস্ট আছে হ্যাঁ কি
কম্পাইলেশন
এত কম্পিটিশন এত জাজমেন্ট
দুটো আর্টিস্ট
Mr. Mitro, we were requesting you if you can conclude your arguments
Yes,
on
then
the
judgment.
remaining part.
But absolutely,
Then-
well,
then
I
you will-
respectfully agree, Milord. That would be very convenient. Chain of thought is not lost. So there are judgments
It's
And
violation
that-
of natural
for
justice.
two propositions. The cross-examination is part of natural justice. So not evidence taken on record without giving the party affected to
Will
be
have no
cross-examined is a nullity.
Hmm.
Therefore, on the basis of that evidence, no conclusion, no judgment, no order can be passed by a court of law against parties affected, namely annulment of that evidence. This will be a provision of law. This will apply to both to the cross-examination of the interviewers later on, and also some of the writ petitioners. It applied to oral evidence of both interviewers and writ petitioners. That's because they are being relied upon by the court for annulling our employment.
Hmm.
Now, for interviewers, there's additional ground. The court thought he had power under 165 to call for examination of interviewers. There, my lord, I respect to join issue that under 165 Evidence Act, it does not empower the court to call as witness interviewers who are not parties to the proceeding. Section 165 means the judgments of gallows, some judgments cited, as a place only section 165 of evidence.